Hello. Check. 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 Hello.
Somebody from registry had called up, etc.
That your lordship will find. Para 11, my lord.
Yes. And where is your reply?
Page 6, my lord. Para 11.
Page 6 of your counter.
Counter, my lord.
Filed by respondent number.
Respondent number 2. And also replied in para 9, last portion.
So if he was if he wanted to apply as a OBC candidate, what is that he would have written in this application more than what he has written?
He would have written as OBC, my lord.
Where?
Category.
Which serial
Serial
number?
number 3. From that only you can come to know that yes, this person applicant belong to this category or OBC or any other category. There is no other.
And according to you, no email was received from him.
My lord, email was received. We have said in para 11, but that was subsequent.
Subsequent to?
Subsequent to the recruitment process, my lord. We have stated, my lord. First of all, we have denied making phone call, para 11. Recruitment cell Guwahati High Court has got no record pertaining to making call to the petitioner. However, it is a fact that in the email dated so-and-so, the petitioner had mentioned that he applied as PWD candidate and informed for the first time as he belongs to OBC category. As there was no post reserved for PWD candidate in the district Valpara, the name of the petitioner was considered a general candidate. In the merit list, the petitioner figured at serial number 13 against 9 unreserved vacancies, of which 5 posts belong to so-and-so, so-and-so. 3 posts in so-and-so and 1 post in the establishment MACT. The petitioner could not be selected because of his lower merit position under unreserved category.
Yes. Where is the list? Yes.
Petitioner has sent the email, page 96, my love. Submitting the page 96, the email. All the documents of the OBC, my love, for the registry. It is mentioned in the petition, OBC, that is why it has been called from the petitioner, my love. What OBC is there, that he belongs to OBC community. It is not mentioned in the petition. So he has got highest mark among the three OBC candidates. He is entitled to get appointment, my lord.
All right, take down. Heard Mr. K. Sharma, learned counsel appearing for the writ petitioner. Also heard Mr. H. K. Das, learned standing counsel, Guwahati High Court, appearing for the respondent number 2. Mr. J. K. Goswami, learned additional senior government advocate Assam, has appeared for respondent number 1. Mr. N. J. Khatrine, learned counsel, is present on behalf of respondent numbers 3 and 4. Full stop. The writ petitioner herein had submitted his application in response to the advertisement notice dated 7/9/2015 for filling up 11 posts of inter alia for filling up 11 posts of computer assistant in the district of Gwalpara, in the judicial establishments in the district of computer typist. Now you write like this, strike that off. On 7/9/2015, the registrar come in charge centralized recruitment cell of the Guwahati High Court had issued an advertisement notice dated 7/9/2015 inviting applications from eligible candidates for filling up 397 posts of computer typist in the district judiciary of Assam spread across 27 districts. Full stop. Full stop. In the advertisement notice, district-wise breakup of the number of posts had been furnished, and it was also mentioned that each candidate would be entitled to submit only one application indicating any one of the district of his or her choice. Full stop. In response to the, full stop. In the advertisement notice dated 7/9/2015, it was further mentioned that that posts would be reserved for OBC stroke MOBC stroke SC stroke ST stroke PWD. W is small, PWD category candidates. Full stop. In response to the advertisement notice dated 7/9/2015, the writ petitioner herein had submitted his application for the district of Gwalpara by identifying himself as a candidate belonging to the persons with disability PWD category. Full stop. Be it mentioned herein that there were altogether 11 posts earmarked for the district of Gwalpara. The petitioner participated in the selection process, but when the final list was published, his name did not appear in the final select list of 11 candidates. First up. Out of the aforesaid 11 candidates, 2 candidates, namely the respondent numbers 3 and 4 herein, belong to the OBC category. First up. The remaining 11 candidates who had scored higher marks than the petitioner were all appointed as general category candidates. Full stop. According to the writ petitioner, he also belonged to the OBC category, and this said fact was, and although this said fact was not originally mentioned in his application, yet subsequently, in response to a telephone call received from the registry, the writ petitioner had sent an email enclosing a copy of the OBC certificate. As such, he ought to have been considered as a OBC category candidate. Full stop. By referring to the materials available on record, Mr. Sharma, learned counsel for the petitioner, has argued that the writ petitioner had scored 84 marks in total, and therefore he had scored higher marks than the respondent numbers 3 and 4, who were appointed as OBC category candidates. Full stop. According to Mr. Sharma, since the advertisement notice initially mentioned about reservation of vacancies for the PWD category, and considering the fact that the petitioner was holding a certificate of benchmark disability, he had applied as a PWD category candidate and not as a OBC category candidate, as the petitioner was under an impression that vacancies will be reserved for PWD candidates, in which case he would have higher chance of being selected. However, when the results were declared, no such vacancies were reserved for the PWD category. According to Mr. Sharma, even if no vacancies were available for PWD category candidate, yet, since the petitioner belonged to the OBC category, he ought to have been selected ahead of the respondent numbers 3 and 4. Hence this writ petition. Full stop. The respondents have contested the stand of the petitioner. The basic stand of the authorities would appear from para 11 of the counter affidavit filed by the respondent number 2. Therefore, these averments made in para 11 are reproduced herein below for ready reference. You have to double tick, full stop. Full stop. Mr. Das has strenuously argued that the registry had never made any phone call to the petitioner, but the petitioner had voluntarily sent a mail informing that he was a OBC category candidate. However, since the email was received on 5/6/2017, that is after the final select list was prepared and published, the respondents could not have acted on the said email sent by the petitioner. Full stop. Mr. Das has further argued that although there were more than 2 OBC category candidates who were selected in the final list of 11 candidates, yet, say even except the respondent numbers 3 and 4, all others were selected as general category candidates based on their merit position. Full stop. Insofar as the argument as regard reservation of PWD category posts are concerned, Mr. Das has argued that the advertisement itself had indicated that that each district will have separate vacancy position. Full stop. Since these are vacancy based cadre, and considering the fact that there were only 11 vacancies in the district of Gwalpara, which fell short of the benchmark of 3%, 3% of posts for being reserved for PWD candidates, it was not possible for the authorities to reserve any such post for the district of Gwalpara. Under the circumstances, submits Mr. Das, no fault can be found with the authorities for selecting the respondent numbers 3 and 4 as OBC category candidates. Full stop. Mr. Das therefore submits that his writ petition is devoid of any merit and deserves to be dismissed. The argument of Mr. H.K. Das has been adopted by Mr. J.K. Goswami and an additional senior government advocate Assam. Full stop. Mr. N.J. Khatoniar, learned counsel for the next para, numbers 3 and 4, has also supported the stand of the department. Full stop. During the course of hearing of this case, the learned counsel for the respondent number 2 has produced a copy of the application originally submitted by the petitioner. A perusal of the said application clearly goes to show that in response to the advertisement notice dated 7/9/2015, the petitioner had applied for the post of computer typist in respect of Gwalpara district, but as a PWD category candidate, full stop. There is no mention of OBC, within quotes, OBC in his application, full stop. Under the circumstances, the respondents have treated him as a general category candidate belonging to PWD category. But since there were no vacancies reserved for the PWD category. Hence, the petitioner's candidature was PWD category for the reasons noted herein above. The candidature of the petitioner was considered as an unreserved category. Full stop. The petitioner had admittedly and evidently scored lower marks than the 9 selected candidates belonging to the unreserved category. Therefore, it cannot be said that the petitioner did have any right of being selected as an unreserved category candidate or as a candidate belonging to the PWD category. Full stop. Insofar as the other argument of Mr. Sharma as regards the claim of the petitioner being an OBC category candidate is concerned, there is no dispute in this case about the fact that the petitioner had not applied as an OBC category candidate. If that be so, the question of considering him as an OBC category candidate would not arise in the eye of law. Even if the respondents have denied of having made any call to the petitioner calling for his OBC certificate, full stop. Even assuming that any such call was made and the petitioner had in fact furnished such certificate subsequent to filing of the application, the same also could not have been taken into account by the authorities after the last date of submission of application form. Full stop. Under the circumstances, it would not be necessary for this court to enter into this disputed question of fact as to whether the registry had in fact made a call to the petitioner, and in response to the same, he had actually sent an email forwarding his OBC certificate. Full stop. After going through the materials on record and upon hearing the submissions of learned counsel for both the sides, this court is of the unhesitant opinion that there is no right of the petitioner which is capable of being enforced in this writ petition. Consequently, this writ petition is held to be devoid of any merit. The same is accordingly dismissed.
Obliged.
Yes, next person. Next. What is this? What is this matter about?
My lord, here the petitioner is the employee of the ITBP, my lord. Here he was joined in the service in the 2021/11/2002, my lord. And thereafter he was sent for 60 days early leave, my lord. That is 23/26 to 22/5/2006. But thereafter he has not joined in the service, my lord. And thereafter he was dismissed from service after 2 years, 5/7/2008, my lord.
All right, none appears for the writ petitioner when the matter is called up. Mr. S. Sharma.
B. Sharma, my
B.
lord.
Sharma, learned CGC is present on behalf of the state.
Right.
Full stop. This matter pertains to the year 2014,
My lord.
and therefore it is not understood as to why the petitioner's counsel is absent today when the matter is called up for hearing. Ordinarily, this would be sufficient ground to dismiss the writ petition for non-persecution. However, considering the fact that it is a matter where an order of dismissal from service is under challenge, this court is of the opinion that the petitioner should be given one more opportunity to appear and argue the matter. Accordingly, these read petitions, hearing of these read petitions stands adjourned for 4 weeks. If the petitioner's counsel remains absent even on the next date, consequential order will follow.
Obliged.
Time being matters, I can.
May it please, madam. My lord, I would try to place my arguments on the basis that the classification which has been sought to be made by the respondent authorities that the institute is purely a research institute is not a reasonable.
So, Mr. Chakraborty, why don't we admit it and post it for hearing?
My lord, issue is that on the next month petitioner will attain the age of
Then
superannuation.
I'll dismiss it. How does it help? You can go in for appeal.
No, my lord.
No case is made out. But we'll see, we can ask them to file an affidavit if a second view is possible. Otherwise, I have seen the matter. You can argue, I can pass a judgment.
My lord.
But if that is what you want, go ahead. There is no case made out. Of course, you are entitled to argue your case,
My lord.
but with our experience and
No, I understand, my lord.
we understand which way things are going. You see. Takes 5 minutes to know what is the
My
issue.
lord. But what I am trying to say, my lord, if they come up with an affidavit, my lord, if the matter is not decided anyway by the next month, my lord, petitioner will, matter will become infructuous in the sense that
This is not a case of discrimination, hostile discrimination. But we can ask them to revisit this decision and see whether it can be reconsidered, keeping in mind the interest of the institution.
well, otherwise, my lord, my submission would be, just for a moment, my lord, but there is no statutory definition which defines any educational institution. In absence of any statutory meaning, excluding a research institute from the purview of educational institution, my lord, that may be perhaps, my lord, arbitrary. My lord, we'll see. A research is essentially a part of education system, and that has been stated by the new education policy of 2020. If I place it to your lordship will see that more emphasis has been given on research. It is not that the research institute are complete alien to education system, normal education system. Just because they don't take regular classes will not oust a research institute.
That is what I'm saying. On that ground, we can ask them to re-examine it and
No.
come back with a response.
Lordship, within a specific time frame, my lord, because in that matter,
We have
Mr.
already filed two affidavits, one additional affidavit also filed. We have narrated all these things, my lord, why it is not educational institutions. And Principal Secretary, Director of Higher Education, he is the important person, my lord. He has already clarified it. Because they are not delivering any, my lord, they are not awarding any certificate, diploma, course, or degree, whatever may be. They are only emphasis on research. Research that too, they are the they are the supervisor like that, to supervise the PhD students. Those are sending from the Dibrugarh University. They train them, they develop their skill, and this is that much. No, they are regular.
You tried somewhere where had Mr. T. Chakraborty, Learned Counsel for the petitioner, also had Mr. T. C. Chutia, Learned Additional Senior Government Advocate Assam appearing for the state. Let this matter be listed before any other bench without me after a week. This matter
Obliged.
shall not be treated as part heard before this court. Yes. You continue. Mr. Chakraborty, I have seen your case. I have gone through it. You see, try your luck. This court will not be able to pass orders which are not strictly in accordance with, but then in any case, put a perception. And later on, I realized something, so I'll not pass a judgment in this case.
Okay.
Yeah.
Obliged.
Time being matter, I can 6.
Yes. Somebody was there in the morning.
I'm for one, two, three.
1, 2, 3.
Whether it is maintainable, madam. Whether it is maintainable, it says so far, paragraph 3, you will also can read it.
Hmm.
Paragraph 3 of the repetition. It's a juristic person, therefore hands the repetition.
So, any other matter in the list? Then I have to rise today because
Let me place any other.
the petitioner's counsel had sought accommodation in the morning, but when the matter was called up today as the last item of the day, none has appeared for the petitioner. Mr. S. Kotakil and counsel for the respondent numbers 1, 2, and 3 submits that the writ petition is not maintainable and therefore deserves to be dismissed on such count alone. Be that as it may, in the absence of the petitioner's counsel, this issue cannot be considered. As such, let this matter